Hey there, this is Professor Nathenson. This is our 11th and our final video on discovery. I'm not doing videos on the materials assigned for next Monday because we are going to have a live class where we can cover those materials. So again, these videos cover the materials for our two missed classes. And of course, you need to have done all of the work as yourself, doing the readings in Glannon, as well as reading the rules and working through the study questions. Watching these videos should be the last thing that you do. All right. Let's talk about Rule 45 subpoenas. Let's keep in mind the purpose of a subpoena. Normally when P sues D has to be served with a summons and the complaint under Rule 4. And in particular, Rule 4K says that when service is done of the summons and complaint, and there's a basis for PJ, the court will therefore have power over that party, right? The court's going to have PJ over that defendant. Of course, the plaintiff doesn't have to be served. There doesn't have to be a basis for PJ over the plaintiff because the plaintiff, by filing the suit, is normally submitting itself to the personal jurisdiction of the court. What about third parties? What about witness 1 and witness 2, right? Are they subject to the personal jurisdiction of the court? Even if they're within the geographic boundaries of the court, say they both live in the state, they're both domiciled in the forum state, that still is not necessarily enough, because after all, to have PJ over the defendant, we not only need to have a basis, but we need to have service of the summons of the complaint, right? Well, a subpoena under Rule 45 does the same thing for non-parties, for those non-party witnesses or those non-parties that have documents and information that's needed for the litigation. So the way you get testimony or you get production of documents, information, things, places from non-parties is via Rule 45 subpoena. And indeed, the subpoena itself has to be served on the non-parties in order for the court to have power over those non-parties. So essentially, the subpoena serves both the notice function, right, letting them know that they have to testify or pony up documents, and it also establishes the PJ, or the power over the power by the court over those non-parties. All right, we're going to go through the questions and go through some of the parts of the rule, and we're going to see that Rule 45 very compactly does a lot of the same things that are done by the other discovery rules, but here they're being done to allow the parties to seek discovery or to get trial testimony or information from non-parties. Question 1's easy peasy. Can a party obtain depositions or document production from a non-party witness? Yes. All right. Can a party obtain both? Yes. How? See Rule 45. All right. Well, we'll go through the whole rule in a minute, but the short answer is under Rule 45, not only can you get testimony, depositions, right, from a non-party witness, you can also get information. You get one, the other, or both. All right. Under what circumstances can a person served with a subpoena serve a written objection? We'll talk about that. If written objection is served, what recourse exists? We'll talk about that below. We'll talk about quashing and modifying subpoena, when the court must do it, when the court may do it. We'll talk about experts. So give me a second. We're going to go down to the rule, and we're going to talk about the parts of the rule. Okay, so continuing, I had to stop the video recording for a minute because Atticus was out back doing his thing. He was barking. So now I'm back. All right. I really just want to go through the rule very briefly. Every subpoena must state the court from which it was issued, have your docket number and the title, okay, and command each person to whom it's directed, so that's going to be the non-party, right, to do the following at a specified time and place. Here's the things that you can do. You can have them to show up and testify, attend and testify. That would be either to depo, that could be at trial, okay. You can have them produce designated documents, ESI, or tangible things, or permit the inspection of premises, right? Now, here's an important thing. The rule has to set out the text of 45 D&E, and that has an analogy in Rule 4. Rule 4 indicates that certain information has to appear in the summons, right? There's certain magic language that has to go in the summons. Well, the same thing is true here. Here, A command to attend a deposition, you have to state the method for recording the testimony. That's very similar to stuff that goes on in Rule 34, excuse me, Rule 30, depositions. All right. In a subpoena, you can have a command to produce documents, ESI, or tangible things, or permit inspection of premises. It can be included in the subpoena commanding attendance at the deposition. Okay, and just like for Rule 30, can specify the form or forms in which ESI is to be produced. Okay, again, like Rule 30. A command in a subpoena to produce documents, ESI, or tangible things requires the responding person to permit inspection, copying, testing, or stampling the materials. Okay, so you get that subpoena, you have to do what it says. Now, it may be that the subpoena is improper or overreaching or other problems, in which case you may be able to object or even move to quash the subpoena, and we'll get to that in other parts of the rule. All right. I'm not going to talk about every part of the rule. It is have to issue from the court where the action is pending. So if the lawsuit is pending in Florida, in the Southern District of Florida, then that subpoena has to issue from the Southern District of Florida. Now, there's two ways to get a subpoena. You can get the clerk of court to issue it, signed but blank, and that goes to the party. Or if you have an attorney, your attorney is licensed in the Southern District of Florida, then that attorney can herself or himself issue and sign the subpoena if they're authorized to practice. Okay. Okay. Obviously, for purposes of notice to the other parties, any subpoena to a non-party witness has to also be served on the other parties. In fact, it has to be served on the other parties before it's served on the non-party witnesses, right? All right. Service. This should remind you of Rule 4, right? The subpoena's got to be served by a person who's 18 years old and not a party, right? And it goes on and on and on and on with that. Again, I'm not going to get into too much detail. I will note the subpoena can be served at any place within the United States. That's interesting because say you have a subpoena that's issued from the place where the action's proceeding, say the Southern District of Florida. Well, that could be served in the District of Alaska. It could be served in the District of Hawaii, and so on and so forth. And you think, well, wow, like how could the federal courts have the power to serve a subpoena in the District of Alaska for an action that's pending in Florida, right? Well, first keep in mind that the sovereign in federal courts is the whole United States, and the Constitution would permit nationwide service of process, right? Second, we'll see other parts of the rule that limit how far somebody can be forced to travel, even under a subpoena. But the subpoena itself can be served at any place within the United States. All right, and here's the part I was just hinting at. Subpoena can command a person to attend trial, okay, hearing, or deposition only as follows: within 100 miles of where they reside, or they're employed, or they regularly transact business in person. Right? So say I live in Florida. All right. Say I live in Florida in Miami. All right. Say I work in Tallahassee. Okay. I commute. And I also regularly do business in Atlanta, Georgia. Okay. Well, this is a place where I reside, a place where I'm employed, and here's a place where I regularly transact business in person. And there's a 100-mile bubble around each of these places where I can be forced to attend trial, hearing, or deposition. Also, I can be forced to go anywhere within a state where I reside, or employed, or regularly transact business in person. So say the suit is in, here's California, really bad picture of California, right? Say I live, work, and do business down here in San Diego in Southern California, but the lawsuit is up here in Northern California. Well, that's going to be a lot more than 100 miles, right? I don't know the exact length of the state of California. I'm going to assume that it's a lot. I'm going to assume that it's like 500, 600, 700 miles. Well, since I reside in California, I can be forced to go and testify in a deposition or hearing or trial way up in Northern California. Okay. But that's only if I'm a certain kind of person. Okay. I'm a party, or I'm a party's officer, okay, or commanded to attend a trial, and I would not incur substantial expense. Okay. All right. Regarding production of documents or ESI, that can be within 100 miles of where they reside, employed, or regularly transact business, and so on and so forth. Now we get down to D. D is where we cut back on subpoenas, right? So remember how I said the subpoena can be served anywhere in the United States, and you got to do what the subpoena says. You think like, wow, well, what if it's really burdensome, or have to go really far? Well, we've already addressed having to go really far up here under Rule 45C. There's other protections under 45D. A party or attorney issuing the subpoena has to take reasonable steps to avoid undue burden or expense on a person subject to the subpoena, and the court, where compliance is required, must enforce this duty and impose appropriate sanctions, including lost earnings and reasonable attorney fees on the party or attorney who fails to comply. Note this says compliance is required. So say the court where the action is the Southern District of Florida, right? But the subpoena is served on me in the District of Alaska, right? All right, well, that's the court where compliance is required, and that's the judge that's going to enforce that duty, which may include, sanctions on the attorneys or parties that violate, the rule by posing undue burden or expense on the person subject to the subpoena. Remember how I said at the beginning that a subpoena can either seek testimony or production of documents or information, one or the other or both? Well, this rule makes it clear. The person commanded to produce documents, ESI, or tangible things, or to permit the inspection of premises need not appear in person at the place of production or inspection, unless also commanded to appear for depo hearing or trial. Now, under 2B, it allows people that are subject not to testimony but to production to make objections, right? So a person commanded to produce documents or tangible things, permit inspection, may serve on the party or attorney a written objection to the inspection, copying, testing, or sampling, right? The objection has to be served either before the time specified or 14 days after subpoena is served, right? And then if there's an objection made, then the serving party, okay, so here's the objection is by X, right, that third party who's the subject of the subpoena. And now here, the serving party, okay, then the party that sought the subpoena can move for an order to compel production or inspection by the person who received the subpoena, right? And then here's what the court would have to do, right? Court's going to have to decide, and the order has to protect the person who's not a party or a party's officer from significant expense. All right. Now, quashing or modifying a subpoena, okay, that's where we're actually changing. Well, quashing would be deleting the subpoena, right? Just throwing it away. Modifying would be changing it. That's a more serious matter with the subpoena. Okay, it's quashing and not squashing. All right, and the difference between Section 3A, what do we want? D3A, 45D3A, and D3B. All right, D3A is about when the court must quash or modify the subpoena. D3B is when the court may, but doesn't have to quash or modify the subpoena. All right, court must quash or modify the subpoena if it doesn't give enough time. It requires somebody to go beyond the geographical limits, right? We're talking about the 100 miles from where you'll live, work, or regularly do business, right? Or within the state, right? Requires disclosure of privileged or other protected matter here. So think privilege that we talked about in another video. Think about work product, okay? As long as no exception or waiver applies, right? Or there's undue burden. So any of these, the court has no discretion. It has to, well, actually does have some discretion here. I'll get into that in a second. But the court, as the starting point, must quash or modify. All right. The court may, on motion, quash or modify the subpoena if if it requires a trade secret or other confidential information. All right, that's interesting because here the court may quash or modify trade secret or confidential research, but it must quash if it requires privileged or protected matter and there's no exception or waiver, right? So, no privilege, think of attorney-client privilege, priest-parishioner privilege, special privilege, Fifth Amendment privilege of not testifying against yourself, and so on. Protected matter, work product, right? But there's other kinds of confidential stuff that don't fall under privilege or under work product. That'd be like a trade secret. Think of, like, for example, on SpongeBob SquarePants, the formula for Krabby Patties that belongs to Mr. Krabs, right? That he keeps in a safe, and that Plankton is always trying to steal. Okay, that's kind of a cartoon but very clear example of a trade secret. Another one is the secret formula for Coca-Cola, right? A huge trade secret. Okay, it actually falls within my field, intellectual property, or other things that aren't trade secret but confidential research or commercial information. Okay, so your business secrets, in other words. Well, here the court can quash or modify the subpoena, but it doesn't have to. What about this one? An unretained expert's opinion or information that does not describe specific occurrences, dispute, blah, 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 blah. So you have an expert, and that expert has not been retained by either party, all right? And we're really not getting into experts, so I'll just talk about this briefly. This person's information or opinion does not deal with specific occurrences in dispute in the litigation. And any study was not at a party's request. Well, this is to prevent free riding by parties, right? Normally, parties who want to use an expert, they retain that expert and they will pay that expert to do research, to do findings, and then, if needed, to testify at trial or at a deposition or both. Okay. This is to prevent free riding on experts that are unretained, right? When a party serves a subpoena on a expert and the expert's not being paid, the expert's not interested in participating, and the parties want a free ride off of the work from that expert. Well, the court has the power, the discretion to quash or modify the subpoena if that unretained expert would be testifying or providing information on things that are not specific to the lawsuit, that are in dispute, and any research done by the expert was not requested by any party, right? So that's to protect the kind of secret research or the freedom of the expert to do their work and not to be sponged upon, not to have free riding on the expert unless the party is willing to retain and pay for the work of that expert. All right. I should note under 43D3B, okay, D3B, right down here, all right. Okay, in the circumstances described in 43D3B, so that's when the court may quash a subpoena. The court may, instead of quashing or modifying the subpoena, order the appearance of production under specified conditions if the serving party shows a substantial need. That should remind you of Rule 26B3 involving work product. Substantial need for the testimony or material that cannot be obtained without undue hardship and ensures there'll be reasonable compensation. So the idea here, of course, is particularly, I think, for the unretained experts, right, that show undue hardship, that you really need this information and you're going to pay the other person, then maybe the court, instead of quashing or modifying the subpoena, might allow the subpoena to proceed as long as there's going to be some paying there and the party really, really, really needs it. And the rest of this I'm just going to blow through real quick. These duties in responding to the subpoena, dealing with documents in the form of producing ESI and all of that, it's very similar to Rule 34, dealing with discovery of documents, things, producing ESI, and all of that. And equally so, this language here about claiming privilege or protection, okay, that deals with things like privilege logs, I talked about in the video on privileges. And here's the procedure for dealing with inadvertent disclosures, right? And again, this is real similar to Rule 26. I believe it's 26B 5, if I'm recalling correctly. You go and looking into it yourself. F and G are just worth quick mentions. F is when compliance is required in a court other than the court that issued the subpoena, it can transfer any motion under this rule. So think of like a motion to quash the subpoena, right? So suppose the litigation is in the Southern District of Florida. The compliance, where the subpoena is served is the District of Alaska. And then there's a motion to quash in the District of Alaska, right? Well, what this does is it allows the District of Alaska to transfer the motion to quash to the issuing court, Southern District of Florida, if the person subject to the subpoena consents or the court finds exceptional circumstances. And then what this here does is allows somebody who's licensed in the District of Alaska to then appear and practice in the Southern District of Florida and to continue to litigate on that motion to quash. And that's important because a lawyer who might be licensed, say, in the federal court in the United States District Court for the District of Alaska, is going to be licensed, say, in the state courts of Alaska and the District of Alaska, maybe other courts in Alaska, say the Court of Appeals up there, as well as the Supreme Court of Alaska or whatever. But it's pretty doubtful that a Alaska lawyer is going to be licensed for the federal courts in Florida. So what this does is allow that Alaskan attorney, they're going to be authorized to practice in the court where the motion was made, which is Southern District of Florida, and file papers and appear as an officer of the issuing court, right? Right? Okay. Finally, this is an important one. If you're subject to a subpoena and after you've been served you fail without adequate cause to obey the subpoena or an order, then you are subject to contempt of court. Don't do that. You get a subpoena, deal with it. You think it's unfair, then make an appropriate objection or do a motion to quash or modify the subpoena. So that's all she wrote, guys. It's a lot of videos. We've gone into a lot of detail. I hope that you have found these to be helpful. That's the end of the videos. As I noted at the beginning of this video, I'm not doing a video on Rule 37 or Rule 26G because we're going to talk about that in class, and I think 11 videos is more than enough for right now. So once again, this is Professor Nathenson. These videos have been on discovery. You have a great day. This is Professor Nathenson, over and out.